Okay, good morning. Good morning, can you hear me? I hope that you can hear me well. Okay, today the lecture is going to be recorded and then the recorded file is going to be uploaded onto YouTube, okay, for your viewing, okay. Welcome again to this online classroom to all my students, okay. This is again the lecture on the law on jurisdictions and contrast. Okay, this is intended to be the lecture for law students of the Faculty of Law of Thammasat University. Okay, so last week we saw the fundamental concepts pertinent to Juristic Acts. Okay, so what we're going to do this morning is to look at the meaning of a Juristic Act and the nature and the essential elements of a Juristic Acts. Okay, remember we have seen from the lecture, of course, last week. Okay, the general statements regarding Juristic Acts. Remember, if you remember well, a Juristic Act it is a what? It is the legal act. Remember, a legal act it is the act which carries some legal consequences. So a Juristic Act it is a legal act which is performed by a person, okay, with an intention to produce some legal consequences. Okay, that is just a general meaning of a Juristic Act. Okay, but in addition to a general meaning of a Juristic Act, we also have a legal definition of a Juristic Act. Okay, this legal definition is indeed provided by the law. Okay, in fact by Section 149. Okay, Section 149 of the Civil and Commercial Code of Thailand. Okay, last week we looked at the general statement regarding a Juristic Act. That is a general statement. Okay, without looking at what the law says. Okay, remember last week we have seen that a Juristic Act again. It is a legal act which is performed by a person with an intention to carry some legal consequences. Okay, but if we look at a definition of a Juristic Act, we can see the definition again in Section 149, and from this definition, we will analyze the crucial elements of a Juristic Act. Okay, now let's have a look at what Section 149 says. Okay, according to Section 149, a Juristic Act means an act which is performed lawfully and voluntarily for the immediate purpose of establishing the legal relations between persons with a will. Something wrong with this microphone saying hello. Hello. So now I switch to this microphone. Just now something goes wrong. Okay, with this microphone. Okay, now I switch to this one. Again, look at 149. 149 says a Juristic Act. It means an act which is performed lawfully and voluntarily for the immediate purpose of establishing legal relations between persons with the will to creating, modifying, transferring, preserving, or extinguishing rights. Okay, so if you are Thai, you can just have a look at the Thai wording. Okay, I also put a Thai wording for you for the purpose of comparison. Okay, now so this is the definition as provided by law. So from this definition, we are going to look at the crucial elements of a Juristic Act. Okay, as mentioned in Section 149. Okay, so from this definition, from the definition in Section 149, we can see that there are in fact four the crucial elements of a Juristic Act. 1, 2, 3, and 4. Okay, the first one is an act in the form of the declaration of an intention. Okay, and the second one is lawfulness. Okay, the third one is voluntariness, and the last one is purposefulness. Okay, so the first one, if you look at the definition in 149 again, the first one it is here. Okay, you can see the word act here in Section 149. The second one, The second element, it is seen in the word lawfully, okay, in section 149, okay. The third one, you can see the element regarding the voluntariness, I mean, in the word voluntarily, okay, in the section 149. And the final one, okay, the purposefulness, you can see this element in the word purpose, okay. So these are crucial elements of a juristic act, okay, according to section 149. Okay, now have a look at, we have a look at, each element in the detail, okay, in the first one, an act. Okay, in order for a juristic act to be made, of course, we need to have first an act in the form of the declaration of an intention. Okay, let's say that I am going to, I'm going to make a contract with you. Of course, I mean, this is a juristic act. So I need to have an act in the form of the declaration of an intention. Okay, the thing is that an act must be done consciously. If something is not done consciously, so that is not regarded as an act. Okay, according to section 149, for the purpose of the conclusion of a juristic act. Okay, so when I say that an act must be done consciously, okay, that means that something which is not done consciously will not be a juristic act. Okay, we have an example. In fact, this example can be drawn from a real story. Okay, a real case which has been brought before the Supreme Court. Okay. In this case, I mean, this case, the Supreme Court case of 2001, if you look at, this case, I mean, this case was concerned with a power of attorney. Okay, the power of attorney. Okay, when you ask something, when you appoint or ask somebody to act on your behalf, that means that you are going to authorize that person to do something for you and on your behalf. When you do so, you need one thing, you need one document, which is known as a power of attorney in Thai. We call this one by Mohammed. Okay, so in this case, somebody just used this power of attorney, but this power of attorney was not completed yet. Okay, it was not filled in, okay, by anyone yet. Okay, so in a way, I mean, we had in this case, I mean, a blank power of attorney. Okay, without without any details being filled in. Okay, so I mean, the thing is that one person, okay, this person just they had the power of attorney without filling in anything at all. Okay, without filling in anything at all. Okay, so that I mean, when another one, let's say that we have A and B again for ease of convenience. I'm going to use the language A and B. Okay, A signed a power of attorney. Okay, in fact, without writing any details of the transactions intended to be made. Okay, and B, when B saw this power of attorney, in fact, A signed in advance. Okay, so A just means signed in advance. Okay, signed in advance. And when B saw this power of attorney, B just used this power of attorney and fill in the details without A's consent, without A knowledge at all. Okay, and when B filled in this power of attorney, B used it for transferring, okay, the land, I mean, belonging to A, okay, to B. The land owned by A, okay, now was transferred to B without A's knowledge. A just signed the power of attorney in advance without filling in any detail, but B just completed this power of attorney, and the details, okay, which was written by B, said that, okay, A wanted to transfer this land to B. Okay, so when B fill in this power of attorney, B just transferred the land to B. The thing is that in this case, A did not know anything at all. Okay, A just signed the power of attorney, Okay, but A did not know at all that B just wrote down, the details saying that, okay, A transferred the land to B. It is B who wrote down the detail, okay, in order to transfer the land from A to B. In this case, the Supreme Court held that, okay, when the act was done without a knowledge, it was not done, okay, the consciously, so that there was no juristic act. There was no juristic act between A and B at all. Okay, so in this case, the land was not transferred to B. The land, okay, still belonged to A. Okay, the land remained owned by A in this case. Okay, what was said by the Supreme Court? Well, it's just that. Okay, in order for a juristic act to be carried out, in order for a juristic act to be made, okay, that it had to, and the juristic act would have to be made through an act. And when we say an act, that means just an act which is done consciously. In this case, means when A did not know at all about this act, we cannot say that this is A's conscious act. Okay, this act was not done consciously by A, right? So that there was, according to the Supreme Court, there was no jurisdiction between A and B. Okay, so the A was named as the authorizing party, B was named as the authorized party. Okay, when B just fill in the detail in this power of attorney without A's consent, without A knowledge, we cannot say that this was a juristic act. Okay, done by A. Okay, so okay, now we are now clear that in order for a juristic act to be made, okay, there must be first an act in the form of the declaration of intention. Of course, the declaration of intention must be done consciously. Remember, okay. The thing is that in order for somebody to act in the form of declaring an intention, okay, the declaration of intention may be done expressly or even by way of implication. Okay, it can be done expressly or even impliedly. Sometimes, okay, the even silence, okay, can be in just an exceptional case. Okay, a silence can also be regarded by law as the declaration of intention as well. But this is an exception. Okay, so the general rule is that, okay, an intention must be declared, okay, expressly or even impliedly. Okay. Now we are going to have a look at, the express declaration of intention. And the express declaration of intention means that is the declaration of intention in an unequivocal manner. Okay, an unequivocal manner just means that in a very clear manner. Okay. You may do so, you may declare your intention, okay, in writing, or you may also declare your intention verbally. If the law does not require you to do it in writing, okay, you are free, okay, to just declare your intention verbally. Or sometimes you can do so, you can declare your intention even by conduct. And, when you do it, when you do something in writing, this is very, very clear. Let's say that I'm going to buy a car from you. I write a letter to you, okay, making an offer to buy a car from you. Okay, so in this case, I declare my intention expressly. Okay, and or I can just go to you and say that, well, I would like to buy this car from you. When I do so verbally, that is also the declaration of intention. Okay, that is of course an act, okay, which is necessary for the purpose of the conclusion of, the juristic act. But the thing is that when we just declare an intention by conduct, that means that, well, the conduct can be understood as declaring intention, even though it is clear from the conduct that is okay. That is, the declaration of intention. Okay, so let's suppose that let's suppose that we have this one. We have the postcard shop. A postcard shop, of course, sells postcards. Let's suppose that somebody just go to this postcard shop and pick up one postcard from this postcard shop. And when somebody just pick up the postcard from this postcard shop, let's say that I pick up this one, and when I pick up this one, even though at that time I did not go to see the shopkeeper yet, but when I pick this up, okay, I just wrote messages on this postcard in order to just send this postcard later to my friends. Okay, when I pick up this postcard and wrote down a message, okay, is that clear that I want to declare my intention to buy this postcard? I think that it is so clear, because if you do not want to buy, then you will not just pick up the postcard from the shelf like this. If you just pick it up, you pick up this postcard and you just write out a message. Okay, it is clear by your conduct. It is clear from your conduct that you want to declare your intention to buy this postcard. They say this is, again, this is still considered as the express declaration of intention, because it is clear. It is clear from the conduct, okay, from your own conduct. Okay, one more example of the declaration of intention, okay, by conduct. The declaration of the express declaration of intention by conduct. Let's suppose that, okay, that you just enter, the Thai style noodle shop, okay, Thai style noodle shop, okay, and this shop sells only noodles, nothing else, only Thai style noodle or pad Thai, okay. So the thing is that the one person, just let's say A enter the shop with with the girlfriend, and A just and A do this. They just show the two finger sign like this. It is clear that when A pop in this noodle shop, okay, and just show the two finger sign like this, that means that he want to order two Thai style noodles. It is clear because the showing of the two finger sign like this can be understood as making an order of two noodles, not anything else. Right, so this is clear again from the conduct. Okay, now in addition to the express declaration of intention, we can also declare our intention, okay, by way of implication. It is an implied intention. It is the implied declaration of intention. Okay, that means that the declaration of intention is not done expressly, but okay, by way of implication, by way of inference from some circumstances, we can infer, okay, from some circumstances that is the declaration of an intention. Okay, I think that I can just give you some example here. Okay, let's have a look at the example number 1 here. Okay, we can just infer. Okay, we can just make an inference from previous dealings. Let's suppose that he has run a bakery shop. Okay, this bakery shop sells a variety of cakes. Maybe orange cake, chocolate cake, banana cake, whatever. Okay, and let's suppose that for many years, okay, over many years, B, he just visits this shop, this bakery shop, and he orders nothing else except an orange cake, just one orange cake. Every time when B visits this shop, B orders only one orange cake. Let's put it today. Today, B, he visits this shop again. And, he looks at A, the shopkeeper, and then he says nothing at all, but he gives this sign, an okay sign. When, B gives A this okay sign, it is what? It can be understood from his past dealing that he wants to make an order for one, the one orange cake, because over the past, let's say 5 years, over many years, B only orders just one orange cake. So when B today just does this, just said, okay, like this, it is understood from the past dealings that B wants to order one orange cake as usual. They say in this case, this is the implied declaration of intention. This means that the declaration of intention, it is not done expressly, but it can be inferred from something. In this case, it can be inferred from previous dealings. Okay, it can be inferred from circumstances including previous dealings. Okay, now let's look at the example number 2. Again, this is example of an implied declaration of intention. Okay, in this example number 2, let's suppose that A, he just pop in a restaurant. Okay, of course, when he pops in the restaurant, he would be brought. He would be taken by the waiter or waitress to a right table. Okay, let's suppose that now. Okay, let's suppose that A, the waiter. A is a waiter. Hello. Okay, so again, sometimes my microphone just dies. In the course of my teaching. Okay, so I hope that this microphone seem to work without dying. in the middle of my lecture again. Okay, so now again we look at this example number 2. Okay, an example of and the implied declaration of an intention. Okay, A entered a restaurant and A was taken to a table. Okay, and the waiter, why A was sitting at why A was at his own table. The thing is that the waiter by mistake, the waiter just served the dish. Okay, so somebody else just ordered the grilled lobster, and the waiter just brought the lobster to a wrong table. Rather than bringing this lobster to the table of the person who ordered it, the waiter just brought this lobster to A's table. And at that time, even though A had not ordered anything yet, but A felt very hungry. A said, A got a feeling that, well, very, very fine. Okay, even though I have not yet made any order, but now the waiter just brings the lobster to my table. Okay, so and I'm getting very, very hungry, so I will have to eat it. So what happened is that A just ate that dish, the grilled lobster. Okay, when A ate the lobster like that, okay, can we infer from this circumstances that A wanted, to buy this lobster? I think that the answer should be in the affirmative. Okay, so even though in this case, when the A did not declare an intention, okay, in an express way, the act of taking the lobster and eating it up, okay, can be understood as an intention to buy this lobster, so that the declaration of intention in this case, it is done by way of implication. It is an implied declaration of an intention. Okay, so I think that these answers seem to be clear to you. Okay, again, when we talk about the implied declaration of intention, okay, we can give you one more example. The example number 3. In this example number 3. Okay, let's suppose that we can just draw an inference from the conduct. Somebody may not declare an intention in an express way, but we can understand from the conduct. We can make an inference from the conduct that that person wants to declare an intention that way. Let's suppose that there is a 10-year-old boy. When this boy is just 10 years old, okay, this boy is a minor. The minor? In the Thai we call Puyao, okay? So in this case, A is still a minor. You have to be mindful. Well, we have not yet been taking a lesson on this one, okay? We have not yet taken a lesson on legal capacity of a minor, but I think that last year when you just took some courses, okay? Not last year, last term of the first year, at the law school, okay, you took some courses, okay, and I'm sure that that course also included some elements or some details regarding the capacities of some persons, including minors. Okay, so a minor, as you are well aware, okay, as you are well aware of, a minor may not enter into a juristic act. A minor can enter into a juristic act only upon consent of the minor's legal representatives. The minor's legal representatives, okay, is just the parents. Let's suppose that the minor want to buy a car. If a minor, let's say that in this case a minor, let's suppose that this is Nobita. Okay, Nobita is still a minor. Nobita wants to buy a car. If Nobita wants to buy a car, let's suppose that Nobita has enough money. He wants to buy a car. Okay, when he buys the car, let's suppose that he does not get any consent from his own parents. So, in this case, when the parents knows about this purchase, the parents will have two choices. Okay, choice one, it is to avoid this juristic act. In order to put this juristic act to an end, okay, the reason why the law requires that the minor can just enter into a juristic act only upon consent of the legal representatives, or in the case of a minor, from the parents, is because the law wants to protect the interests of the minor. The minor is not careful enough. The minors may be so careless. Okay, the minor runs the risk of the being put at disadvantage. That's why the law would like the legal representatives or the parents of the minor to take care of the minors. Okay, to make sure that the juristic act to be done by the minor is going to serve interest of the minors. But in this case, Nobita buy this car. Nobita has purchased this car without consent from the parents, so that this contract is voidable. The law says that if a minor enters into any juristic act without consent of the legal representatives, then that juristic act will become voidable. When it is become voidable, or in Thai mokia, that means that it remains valid until it is avoided. If in this case, if the parents want to avoid this agreement or this contract, then this contract will become void. But if the parents say that, well, fine, even though our son did not get our consent, but we now consider that this contract seems to be fine, okay, the parents as the legal representative may just ratify this juristic act. So the parents may go ahead with their ratification. So these are two choices, either avoidance or ratification. Let's suppose that the parents did not ratify, did not give any ratification directly, okay? But the thing is that, let's suppose that in this case, this minor, okay, this child has not yet payment. Okay, so this child has bought this car without making payment yet. When the parents knew about this purchase, the parents just do what? The parents just decided to pay the price. When the parents just made payment of the price like this, even though the parents did not say anything that they wanted to ratify the sale agreement which was made by the son and the car dealer, but we can understand from this conduct that this is the ratification. This is the ratification by the parents. Okay, so we can infer from this conduct that this is the ratification, so that this juristic act, it is made by the declaration of intention by way of implication. Okay, ออกการแสดงเจตนาโดยปริยาย. Okay, now silence. Okay, remember that we have talked about the express declaration of intention. We have talked about the implied declaration of intention. Okay, now declaration of intention by silence. Can silence be regarded by law as the declaration of an intention. If we go back to this slide, going back to this slide. Okay, remember there are three ways the declaration of intentions, okay, can be made by in three ways: expressly, impliedly, or even by silence in some exceptional cases. Okay, so the general rule is this: with respect to silence, the general rule is that silence cannot be regarded by law as the declaration of intention. Okay, nobody can say that, well, my silence can be regarded by law as the declaration of an intention. Okay, we can, this is the rule. Okay, but there is also an exception which we are going to go to later. Okay, back to the rule. The rule is that silence cannot be regarded as a declaration of an intention. Okay, we have an example, in fact, a very striking example from the case known as the inertia selling. Let's suppose that the one company, let's say that is the magazine company. Okay, let's say that the Tom magazine. Okay, in the Bangkok, the branch in Bangkok just send you the magazine. I mean, together with the letter, they send you the magazine. Okay, let's suppose that A is, the magazine company sent to you. You are B. Okay, the magazine together with the letter. The letter say that, well, okay, when you receive this magazine, and if you just do nothing, if you do not return the magazine to the company will check that, well, you have, accepted that magazine. Okay, the company offer this magazine to you, and you have accepted the magazine, so that a contract is made between you and the magazine company. In this case, okay, can we say that there is a contract between the magazine company and you? Of course, I mean, the contention addressed by the magazine company is that, okay, you have accepted their offer by silence. They have made the offer to you, okay, to sell that magazine, and then even though you did not say anything, you just remain silent. Your silence can be regarded as the declaration of intention to accept the magazine's company's offer. Okay, can we say so? The answer is no. The rule is that silence cannot constitute any declaration of intention. So in this case, there is just an offer from the magazine company without an acceptance from you, because you just do nothing. You just keep silence. Silence cannot be interpreted as your acceptance of the magazine's company's software. Right. But there is an exception. Okay, the exception, normally it is an exception set by the law. Okay, it is a case which is provided by law. The exception is that in some circumstances, the law will deem that your silence is, the declaration of intention. Right. We have, in fact, a very striking example from the lease agreement, a lease สัญญาเช่า. Right. Let's suppose that A and B, they make a list. Remember the list? People in Thailand normally call this agreement using the name a high or property, but I prefer the word the lease. Okay, the lease seems to be more widely used. Okay, so when A and B, they made a list, let's say that A is the lessor. Remember the word lessor or the letter ผู้ให้เช่า. B is the lessee. Okay, ผู้เช่า, the lessee or the hire. Okay. Let's suppose that A and B, they make a list for A grants a list to B for, let's suppose that for how many years? For 3 years. Okay, So at the end of the 3-year period, okay, when the lease ends, in this case, the lease say that it is the lease for just 3 years. The duration of this lease is 3 years. But when this lease ends, B still remains in possession of this house. Let's say that it's a lease of the house. And A, the lessor, A see that B still possesses this house. A raises no objection. Okay. In this case, when at the end of the agreed term of the lease, if the lessee remains in possession of the property, and the lessor knows that and raises no objection to the lessee's possession at all, in this case, the law will regard that this is the party's declaration of an intention to renew this lease for an indefinite period. So even though the parties to this agreement have said nothing at all that they wanted to renew this lease, they just keep silence. B, just continue his possession of this house, and A, upon knowledge of B's, continued possession of this house, B raises no objection. Both A and B just, they keep silence. In this case, the law regards this silence as the declaration of intention of the parties to renew this lease for an indefinite period. Okay, so this is position, in section 570 of the CCC. Okay, if you look at 570, it provides as follows: if at the expiry of the agreed term of the lease, the lessee remains in possession of the property, and the lessor, with the knowledge of such fact, raises no objection thereto, it shall be deemed that the parties have renewed the contract for an indefinite term. But again, this is just an exception. Okay, the rule is that silence cannot be regarded by law as the declaration of intention. Okay, except in some, some rare and very, very exceptional cases in which the law deems silence as, in some way, the declaration of an intention. Okay, so that is the first element of a juristic act. Okay, I think that I bring you back to the 4 element of a juristic act. Okay, can I just bring you back to this 4 element? Okay, now that in order for you to know where we are, okay, we are now talking about this 4 element of the juristic act. Okay, so element of a juristic act, 1, 2, 3, 4. We have discussed the first element, which is an act in the form of the declaration of an intention. Now we are moving forward to discussing the second element of a juristic act, lawfulness. Back to what section 149 says. A juristic act means an act which is performed lawfully. So that you can see the word lawfully. Okay, that means that what is required of a juristic act is also, among others, it is also lawfulness. An act which is done must be lawful. A juristic act which is intended to be done must be lawful. Okay, so that means if you want to do something which is not lawful, that is not going to be, a valid juristic act. Okay, so now we are going to see this in fuller detail. In fuller detail, okay, so remember, an act which is intended to be done must be lawful. If an act which is intended by you is unlawful in some way, then you cannot have a valid juristic act. We have examples of unlawful acts. Okay, let's say that the Adam and Ben he entered into an agreement. Adam made a contract with Ben for hiring Ben to be his gunman. Okay. Adam said, "Well, Ben, you can be my gunman. Okay, you can just kill anyone which is named by me. Okay, that is illegal. In fact, that is unlawful. So that that we cannot have a valid juristic act. I mean, here. Okay. Now, moving on to the next example here. Let's say that Adam he executes a will. The law say that for anyone to make or to execute a will, that person must be at least of 15 years of age. Let's suppose that Adam he executes a will when he is below 15 years of age. The law say that the law provides that a person who makes a will, the testator, we call the person who makes a will as the testator. A testator must be at least 15 years of age. If Adam makes this will when he is below 15, that means that he does something which is not permitted by law. That is something unlawful, so that this juristic act cannot have the legal effect. It cannot have it cannot be a valid juristic act. We will have a look. We will see later consequences of a juristic act. Okay, which is made in derogation from the requirements of law. Okay, now we just look at the elements, the crucial elements of a juristic act. Now, have a look at the next example of lawfulness of a juristic act. Okay, let's suppose that one person he already has a spouse, he has a legal wife. After that, he enters into a marriage with another girl, another lady. In that case, that is unlawful, because Thai law, as with the laws of many countries, does not allow the remarriage. If you remarriage, when you are still married, you are not a divorced person yet. Okay, when you already have your spouse, you cannot marry another girl. You cannot marry another person. If you do so, that is unlawful. So this is a juristic act which is not lawful. It is an act which is unlawful, so that it cannot be a valid juristic act. Right now we are moving to the element number 3. The element number 3 is voluntariness. Again, if we go back to look at what is said in section 149, I'm trying to bring you back to 149, okay? To say this third element, 149, again, 149 says, okay, a juristic act. A juristic act means, wait. Sometimes my pen doesn't write. A juristic act means an act which is performed lawfully and voluntarily. You can see that voluntariness. This is the third element, and now we are talking about the details of this. The third element. Okay, the third element, voluntariness. Of course, the law focuses on what? The law put emphasis on free will. In order for a juristic act to be made, it must be made by free will. เจตจำนงอิสระเจตจำนงที่เป็นอิสระเจตนาอิสระ Okay, so you should be free from any factors which vitiate your will, any factor which make your will bad. Okay, we call this one vitiating factor, the factor which vitiate the will. Okay, vitiate mean what? Vitiate mean make something bad. Okay, if there is any factor which vitiates the will, okay, which is required to make a juristic act, then we cannot have a valid juristic act. Simply because that is not a product of voluntariness. Okay, so there may be some factors which vitiate the will. There may be the fraud, คนช่อฉน There may be duress, ข่มขู่ or mistake, สำคัญผิด Okay, so if A and B, let's suppose that Adrian and Bella, okay, Adrian and Bella, if they make a contract, let's suppose that Adrian, he has the painting. He wants to sell his painting, okay, to Bella. And he tells a lie to Bella that, that the painting is by a famous artist. In fact, it is not by a famous artist at all. But we believe in the statement given by Adrian. Bella believed in, the statement given by Adrian. So, in reliance on such false statement, Bella decides to buy this painting from Adrian. We have a contract between Adrian and Bella here. Of course, a contract is a juristic act. But in this case, this contract, i.e. a juristic act, cannot have the valid effect simply because it is made not by free will. If Bella had known that the painting was not by the famous artist, then Bella would not have bought this painting at all. See? So in this case, we have no voluntariness, which is one of the crucial elements of a juristic act. So that without voluntariness like this, the juristic act in question might not have, the legal effect. In some cases, it will be void. In some cases, it will be voidable. Okay, we will talk about that. Not today, but maybe the next week. The consequences when the concept of voidness and voidability and consequences of voidness and voidability. Okay. Now coming to the case of jurors again. Okay, and I would like to to reiterate this. All juristic acts must be done through free will. If the will of the parties is not free, then that juristic act may not have the full legal effect. Let's suppose that again we have Adrian and Bella. Adrian threatens to shoot Bella if Bella does not execute a will giving Bella's house to Adrian. Adrian wants this house, okay, and Adrian say, well, Bella, if you do not execute the will, bequeathing means giving, okay, giving by a will, bequeathing your house to me, then I'm going to kill you now. So Bella in this situation is put in fear, in fact great fear, the fear of losing her own life. So he just execute the will, bequeathing her house to Adrian. In this case, we can see that the execution of the will, it is not the product of voluntariness. So that the will, which is of course a juristic act, okay, will not carry full legal effect. Okay, the one more example here, okay, the mistake. Okay, when you do something, okay, through your free will, that means that you must have correct understanding, okay. But if you do something on the basis of incorrect understanding, you make a mistake about something fundamental or something very, very important. In that case, it will have some effects on validity of a juristic act. Okay, let's suppose that again, Adrian, he signs a loan agreement. When he signed the document, okay, he believed that he is signing a guarantee. He believed that he is the guarantor for his son's debt. But in fact, what he is signing, it is not a guarantee. The document say that he is the co-borrower. He is a co-borrower. He borrowed money together with his own son. Adrian believed that he is signing a guarantee, but in fact, what is signed by him, it is the contract under which he is a co-borrower together with his own son. See, so that it is not a guarantee, it is in fact a loan agreement. So a loan agreement, it is a product. It is not a product of Adrian's voluntariness, because Adrian just makes a mistake. He misbelieves that this is, the guarantee, not a loan agreement. So that, that in this case, we have a Juristic Act, which might not, carry the full legal effect. Okay. Now, let's move on to the element number 4. The element number 4 is purposefulness. Okay, with respect to this element, a Juristic Act must have some purpose. Okay, the person who makes a Juristic Act must do. The person who makes the Juristic Act must do so for a particular purpose. Okay. He must have a specific purpose in order to create or establish legal relations. Okay. Towards some effects on rights. He wants to A and B, they want to enter into a deal. He wants to enter into a Juristic Act. A and B must have some specific purpose. They want to establish legal relations towards some movements or in relation to some rights. Maybe they want to create some rights. Maybe they want to modify some rights. Maybe they want to transfer some rights. Maybe they want to preserve rights or even extinguish the rights. Okay, so the A and B, when they want to make a Juristic Act, okay, A and B need to intend, to establish some legal relations in order to create the right, modify the rights, transfer rights, preserve rights, or even extinguish rights. Okay, that's I'm going to give you some example, of the purpose of purposefulness for the purpose of the conclusion of a Juristic Act. Let's suppose that we have Alex and Betty again. In the example number 1, we have Alex and Betty. Alex makes a contract with Betty in order to sell his own car to Betty for 800,000 baht. In this case, Alex is the seller. Okay, Betty is the buyer. Alex, in this contract, okay, of course, a contract is a Juristic Act. In this contract, when Alex and Betty make this contract or make this Juristic Act, okay, they make this Juristic Act in order to establish between them, okay, legal relations for the purpose of establishing some rights. In this case, both parties will have some rights. Alex, as a seller, will have the right to claim the price, of course. And of course, Betty, as the buyer, has the right to demand to demand delivery of the goods from the elect. Okay, elect the seller has the right to claim payment of the price, and Betty has the right to demand elect to deliver the goods to Betty. Okay, so this juristic act is made, okay, with intention to establish between Alex and Betty legal relations for the purpose of creating some rights. Now, okay, look at example number 2 here. In the example number 2, let's suppose that Alex makes a will. Pinai come. Alex makes a will saying in the will that when he dies, he wants all his property to go to Betty. Betty, who is Alex's ex-lover. Okay, in this case, Alex is a testator. Betty is the beneficiary. Okay, you can see that in this case, of course, the will. The will is a juristic act which is made in order to establish legal relations between Alex and Betty, okay, for the purpose of creating the rights for Betty. When Alex dies, Betty will have the right to do what? To claim the property named by the will. Okay, in this case, and the will say that all Alex's property will devolve or upon Betty, so that upon Alex's death, Betty can just claim, all property owned by Alex, right? Now, okay, we are going to look at, the modification of rights. Remember, a juristic act can be made. A juristic act can be entered into for the purpose of, the modifying some rights. The two parties A and B, they make a juristic act to establish between themselves, okay, legal relations, okay, in order to modify some rights. That means that they already have some rights, but they want to modify. Okay, they want to make modification to the rights. Let's suppose that we have again. I try to use the word. The name Alex and Betty for your convenience. Okay, Alex again make a contract to sell his own car to Betty for 800,000 baht. Okay, let's suppose that later Alex and Betty they just made an agreement in order to change the originally agreed price from 800,000 baht to 900,000 baht. We can see that the agreement which was subsequently made by Alex and Betty, it was made to establish legal relations in order to modify the rights. Now the rights of the parties have been modified. Remember, Alex, who has the right to claim, the price of 800,000 baht now, okay, can have the right to claim the price of 900,000 baht. Okay, so this is example of the modification of the right. Now, look at example number 2, the example of the modification of some rights. Okay, again, Alex and Betty. Alex has taken a lease of Betty's room. Betty has a room, okay, and Betty just grants, a list of this room to Alex, so that Alex is what? And this Alex is the lessee, okay. Betty is the lessor, okay. So the agreement say that the Alex would have to pay the rent of 5,000 baht per month. This is the rent, okay. The term of this lease is 3 years. So that means in this 3-year period, Alex will have to pay, the monthly rent of 5,000 baht. Okay. Let's suppose that after 1 year, Alex seems to be broke. He does not have much money. Okay, he is so worried. I mean, he has no money to pay the rent. But the thing is that Alex, he is from the farmer's family. Okay, he is also the farmer. His parents grow some rice. Okay, so that Alex has some jasmine rice. He does not have 5,000 baht to pay the rent, but he intends to use the jasmine rice as the rent. So Alex and Betty, they may enter into a new agreement, say that the rent, which is specified in the previous list, that is now changed from the money 5,000 baht a month into the 100 kilograms of jasmine rice. So the agreement made between Alex and Betty on this occasion, it is the Juristic Act. I mean, for the purpose of what? For the purpose of establishing legal relations, okay, with a will to modifying rights. Okay, so I mean, after this agreement, okay, the right to claim what? The right to claim the rent of 5,000 baht is now changed into the right to claim 100 kilograms of jasmine rice each month. All right. Now, transferring the right. Okay. Let me just make a check at the screen first, okay, to see whether anything wrong with the screen, okay. Okay, the things seem to go on very, very well. No the technical problems in culture. Okay, according to my observation now. Now I'm going to move forward to the Juristic Act, which is made for the purpose of transferring the right. Okay, of course, transferring the right, it is one of the purposes of the Juristic Act. Okay, we have an example here. Let's suppose that we have Amanda Company Limited. This company operates a 5-star hotel. Okay, so we have Amanda Hotel here. Okay, and whom? And the Bermuda International School. See, we have two parties. Okay, the first one is Amanda Hotel. The second one is Bermuda International School. Okay, what have they done here? Okay, they have made what? They have made a contract. The contract to hold an international conference. The hotel will have to, hold an international conference together with the provision of catering services, providing food as well. Okay, during the conference, and the hotel will charge to 2 million baht. Okay, so the hotel, Amanda Hotel, agrees with Bermuda International School to hold an international conference for the school, including the provision of food during the conference in return for the remuneration of 2 million baht. Okay, the thing is that, of course, we have this agreement. After this agreement, from this agreement, you can see that Amanda, the hotel, okay, has the right to do what? Has the right to claim, the remuneration of 2 million baht. The thing is that after, Amanda made an agreement with Bermuda, Amanda agreed to transfer the remuneration of 2 million baht to Catherine, okay. Amanda subsequently agreed to transfer to Catherine the right to claim this remuneration of 2,000 baht, okay, from the Bermuda. Okay. So in this case, after they have made this new agreement, who is going to claim the remuneration? The answer is Catherine, not Amanda Hotel anymore, because Amanda Hotel, Amanda Hotel has agreed to transfer the right to claim to, 2 million baht to Catherine in this case. So the agreement, which is newly made here, it is a juristic act which is made, in order to do what? In order to create or to establish legal relations, with a will to transferring the rights. Now, preserving the rights. In many situations, persons may also make juristic acts in order to preserve some rights. Let's suppose that we have the contract, between A. A is the contractor. Sorry, A is somebody, who engaged a contractor. A engaged B. B is contractor here. A, in a way, hire B to make some work, to just perform some construction work for A. B is contractor. Let's suppose that A engaged B to carry out, the construction work at the shopping complex owned by A. And this contract set the remuneration at 15 million baht. This is, of course, a construction contract. According to this contract, if B, the contractor, delays in the construction, the contract requires B to pay penalty at the rate of 10,000 baht per day. So for each day of delay, B, the contractor, will have to pay a penalty of 10,000 baht. Let's suppose that B, the contractor, completed the work 60 days late. The construction work was completed 60 days later than the date specified by the contract. So in this case, A wanted to demand the penalty payment from B. Remember, the contract said that B would have to pay 10,000 baht per day for the delay. In this case, given that the delay is for 60 days, so that the penalty payment would be 10,000 multiplied by 60, it would make 600,000 baht. So A demand B to pay 600,000 baht as penalty payment. B in this case argued. B said, no, I'm not going to pay this amount because in the last 7 days of our work, we had a very serious storm, So the delay which occurred during the last 7 days, it was, caused by the storm, and it is not B's fault. That is the argument raised by B, So B said, we are not going to pay, we are not going to pay the penalty payment of 600,000 baht. We would have to pay 600,000 baht minus 70,000 baht because the delay which occurred during the last 7 days, it was caused by the storm, which was not B's fault. This is the contention made by B, When A receives B's letter like that, A just now writes a letter to B saying that, no, B, we don't listen, we won't listen to you. We still believe that, that your delay, it is caused by your own fault, not by the storm. So that we insist that you will have to pay this amount, 600,000 baht, as demanded in our previous letter. So when A does so, i.e. writing letter to B, informing B that A wants B to pay the original sum of 600,000 baht, that is the juristic act made by A in order to preserve A's right. It is a juristic act made to establish legal relations between A and B in order to preserve A's rights. Okay. Now, we are going to go to the final purpose, extinguishing rights, to put an end to the right. Okay, the extinguishment or extinction of rights. Okay, so sometimes A and B, they may enter into a juristic act. Okay, in order to just put an end to some rights, or sometimes one party alone may just make a juristic act in order to put an end to some rights. Okay, let's suppose that the A and B, they make a contract. Okay, A and B, they make a contract. Let's suppose that the A is a hotel. B engages A to just provide a wedding service for B at the remuneration of 600,000 baht. And the contract specifies that, okay, the remuneration would have to be paid in 2 installments. Okay, B would have to pay the first installment in the amount of 200,000 baht 2 weeks after the signing of the contract. This is the first installment, okay? And the second installment, the remaining 400,000 baht, it is due to be paid, okay, a week after the wedding celebration. Okay, so and the contract also say that if B fails to make any payment in time, then A, the hotel, can just terminate the contract. Okay, what happened is that after the contract has been signed, 1 month passed without B making any payment. B failed to make payment. What does the contract say? The contract say that if B failed to make payment, okay, on time, then A, the hotel, has the right to terminate the contract. So when B, okay, defaults on payment, A now writes a letter to B. A writes a notice to B saying that A wants to terminate this contract. So the letter written by A to B, it is a juristic act, okay, which is made for the purpose of, extinguishing the rights. The rights under this contract will have to come to an end, in fact, okay. Now, one more example of, extinguishing the right. Let's suppose that we deal with the case of a will, Pinai. Okay, A is a father. He makes a will saying that he wants to bequeath. Again, bequeath mean what? Bequeath mean give by the will. A says in the will that when he dies, he wants to bequeath the following property to the following persons. He wants to bequeath his luxurious condominium unit to his eldest son. He wants to give shares in the company to his daughter, and the remaining property will go to his wife. You can see that there are 3 persons who are the beneficiaries of this will, okay? The son, the daughter, and the wife. The son is entitled to inherit what? The condominium units, okay? And the daughter has the right to the shares in the company, and all remaining property will go to the wife. Let's suppose that when A dies, the wife just writes a document saying that the wife does not want to receive any property named by the will. The wife wants to renounce the legacy. She does not want the remaining property. She does not want the property, okay, which remain from the entitlement given to the son and the daughter. The wife is rich enough, and the wife want all other children to share the property, the remaining property. In this case, the renunciation of the legacy here, the document which is made by the wife in order to renounce the legacy, in this case, it is a juristic act, which is made in order to extinguish the rights, her right to get, the remaining property named by the will just come to an end in this case. Okay. Now I hope that you can, that you can now, you have, correct understanding of the crucial elements of a juristic act. Remember 4 elements. First, the first one is what? An act. The second one is lawfulness. The third one is voluntarily, and the last one, is the purpose. Correct? The purpose. Now, I just ask you a question. When we are clear now, we have a clear picture that there are these 4 elements. 1, 2, 3, 4. There are these 4 elements of a juristic act. Okay, now my question is this. Supposing that any one of these 4 elements is missing, doesn't mean that there is no juristic act at all. A juristic act, a juristic act consists of these 4 elements. 1, 2, 3, and 4 elements. Doesn't mean that if, let's say that the element number 2 is what? If you go back to number 2 is lawfulness, or number 3. Let's suppose that if the element number 3 is missing, does it mean that there is no juristic act at all? Well, we can answer this question, in 2 ways. If our answer is going to be based upon logic, upon different logical thinking, the answer should be that, well, there will be no juristic act at all, because a juristic act, it is made by these 4 elements. It is made out of these 4 elements, so that when any element is missing, then this juristic act cannot be formed at all. Right, this is the answer based upon our logical thinking, But I must say that even we resort to the logical thinking like that, the law may not take that logical thinking, because in some cases, the law say that if some elements, if any one element is missing, the juristic act in question may be void. But in some cases, the law say that even though one of these elements is missing, the juristic act is still there, but it is voidable. It is voidable. The word voidable means that it remains fine, it remains valid, unless it is later avoided, unless it is later set aside. So I'll give you an example. Let's suppose that A forces B to sell B's car to A. B has a car, and they say, well, B, I want your car, I want your car. If you do not want to sell your car to me, now I'm going to attack you very, very seriously. B is afraid of this threat, and B sell his car to A. You can see that in this case, B is not willing. What is missing is what? what is missing is voluntariness, right? Remember, voluntariness, it is one of the 4 elements of a juristic act. But in this case, even though the logical thinking may lead to the conclusion that, well, when the contract, the juristic act between A and B, it is made without voluntariness, then there is no juristic act at all. But in this case, if you look at Thai law, and I am sure that the same position is also found in the laws of some other countries as well. Okay, the law say that in this case, even though B is forced by A to sell his car to A, the contract is made under duress. The contract in this case is made under duress. This contract remains valid. It is just voidable. So it's up to B. If B has 2 options, B may avoid this contract, or if B does nothing, okay, if B does not avoid the contract, then the contract will remain valid. So we can see that even though the element number 3 is missing, we still have a juristic act, because the law say that this contract, this juristic act, it is just voidable. It remains valid until it is avoided. If B, in this case, does not want to avoid the contract will just remain valid. So we can conclude that do not just take it that if one of these 4 elements is missing, then there is no juristic act. The law just say that in some situations there is no juristic act. The juristic act will be void, but in some situations the juristic act, okay, is still there. It remains valid, but it is subject to avoidance. In some case, the law even go too far. The law say, well, for the reason that we have to protect, for instance, the interest of the third person or the interested person, we will not allow anyone to avoid the juristic act at all, even though it is made okay, without voluntariness, something like that. Okay, so I hope that you now have correct understanding of a juristic act, okay, or the crucial elements of a juristic act. Okay, we will at the end of the lecture, at the end of this lecture, okay, we are going to have a look at the validity of a juristic act. Okay, so I hope that you'll find, okay, at the end of this lecture, we will have another lecture, okay, very, very soon. Okay, so thank you very much for changing, and see you in a few hours, okay, because after this lecture, we will have a new lecture in a few hours. Thank you very much, and see you soon.